Global iTech Podcast. Global iTech Podcast.
Hello and welcome to episode 4 of the Global iTech Podcast. In the last episodes, we were largely focusing on privacy for individuals. And as usual, I'm your host, Joshua, and my co-host, Anne. And welcome to this episode.
Thank you, Joshua. It's good to see you again.
Good to see you too.
Yes.
We shall be focusing on privacy for organizations. So all the people who are concerned with privacy in their respective organizations, this therefore addresses you. And in this episode, it's where now law gets to meet tech. We get to unpack what are these things that the law talks about in terms of what an organization needs to do. So Anne, unpack for us when it comes to the context of data protection law, and we've already seen in the different jurisdictions we have laws that have been enacted to address issues of data protection. You've clarified that they focus largely on anyone who's using my personal data for commercial gain. So help us understand within the context, if you use the Kenya law, within the context of the Kenya law, does every organization have to comply with this law? Or is it specific categories of organizations that need to? Case in point, I have an Airbnb business. Do I need to comply with this law?
Thank you. Yes. Thank you very much. Who needs to comply?
Yes, who needs to comply?
Yeah. So I always say that you can't understand who needs to comply if you don't understand a little bit of the technical terms. So let me get a little bit technical for of organizations that need to comply. Yeah. So we have the term data controller.
Okay.
So basically, that is any organization that determines the purpose and the means of processing personal data. In other words, this organization makes up its mind to go out there and collect information from people for a specific reason. Okay. For example, a hospital.
Yes.
It says, for me to provide you service as a patient, I am putting myself out there as a hospital. Yeah. For you to get a service from me, I need to get your personal details. Yes. And then I give you either a form or an app or whatever to fill in. So because I have made that decision of how you're going to give me the information, and I've given you the way to give me that information, then I'm a data controller. Okay. And there are many organizations that fall under that definition. You can think of a bank, a hospital, a school, a church.
The Mama Mboga?
Mama Mboga. Does Mama Mboga collect personal data? Do they determine purpose and means?
They'll keep my phone number. They'll get my phone number.
Yeah.
Yes.
Arguable. Yes. Thankfully, the Act says any person or entity. So it doesn't even just have to be a limited liability organization.
Or even a person.
Or it can be even the government. Yeah. Okay. It can be a charity. It can be your club where you go for golf. Yeah. Yes. So any person or entity that determines purpose and means of processing data is supposed to comply with that. Yeah. Then we have another category of people who perhaps don't have a direct interaction with me as an individual. They don't ask me directly for information, but somehow they'll interact with my information. They're sort of like in the background. For example, if this hospital is using a cloud provider to provide their system.
Yes.
Yeah. So they don't see me, and maybe even let me give a better example of smart applications.
Yes.
Many people don't know smart, and I think it's either by design or by the way you are structured. Yeah. Smart offers hospitals in countrywide or medical service providers the ability to identify patients in the claims process. So if you've ever gone to a hospital or clinic and been asked to provide your fingerprint somewhere, that fingerprint belongs to Smart. It's Smart that does that business. So somehow Smart is processing my data and I have never interacted with them as an individual. I don't even know. I thought that device was for the hospital. So in that way, Smart is a third party who has been contracted either by insurance providers, mostly by insurance providers, to provide that service of biometric identification during the process of being treated in hospital. And then they give you this card. And many times you'll see it's written Smart.
Yes.
And you probably think they are calling you Smart. But it's the name of the organization. So those kind of organizations that are playing middleman are called data processors. They stand in the middle of me and the organization that picked data from me, and they are appointed by the organization that picked data from me. So for example, in the insurance scenario, I will interact with the insurance provider when I'm seeking a policy. Then the insurance provider will contract Smart. So those organizational dynamics are important because the two organizations both have obligations under the Data Protection Act. So I think that's what I can say when we start looking at who is meant to comply. Now, Airbnb, you asked an important question. I own an Airbnb. And that's a perfect example. Who is the controller? I'm asking you.
It's Airbnb, the organization, not me who's contracted by Airbnb.
Interesting. And I like that confusion because that's how the scenario plays in real life. People don't know to distinguish who is who. But in reality, me, the owner of the premises, I am using Airbnb platform. So who collects for me? It is Airbnb. Yeah, you're right. So Airbnb becomes the controller. And it is picking information and processing on my behalf. It can also be playing two roles at the same time. It can be both controller and it can be processor.
How?
Now, let's say, for example, Airbnb tells the providers, you are the one administering everything on this platform. All I'm giving you is a platform. Like that's what Microsoft tells us. I'll give you 365. You configure your emails, do what you want to do, use it for whatever. My job is you just pay me subscriptions and I've given you a platform. In that way, then 365 is a processor.
It's a processor,
contracted by Smart. Who is a controller. But then 365 also has its own employees. They hire their own people. So they go out to the market and ask for CVs and hire. But because they are an employer, then they are also a controller. So they play both roles. They can double hat. You can be a controller and a processor.
And a processor at the same time.
Where am I going with this? Where I'm going is those relationships are often complex. It's not easy to understand which one you are in a given scenario. So you do need to do that analysis if you're trying to identify whether you have some liabilities that are attaching. You need to check, in this situation, who am I as an organization? Was I a controller or was I a processor or was I both?
With you both. Okay, makes sense. So let's look at the obligations, despite the category the organization falls in, whether you're processor or your controller. What are the general obligations that every organization, despite the category you fall in, must adhere to as per the laws around data protection and privacy?
So mostly, let's drop the controller processor conversation and say organizations that collect information from people have a few obligations. Number one is they have to follow what we call the principles of data protection. And in the data protection law, there's already 8 principles. Principles are like guidelines. Actually, when you look at the law, there are one-sentence statements. With a lot of loading in each statement. For example, one of the principles is every organization must respect the privacy of the individual from whom they collect the information. So you respect it, you collect it, and use it in accordance to my right to privacy. There is no guidance in the law about what that is. What is respect for privacy? So it is expected that you as an organization should sit back and ask yourself, the way I am designed as an organization, do I respect privacy? If I think about how phone calls are collected, are picked up in this organization, is it geared towards respecting people's privacy? Can anyone overhear every conversation? Yeah. If the conversations are being recorded, are they secure?
Okay.
Can they be intercepted? That's a way to think about respecting people's privacy.
Yeah.
It's also around how documents are stored and how your filing looks like, especially physical records.
Yes.
I like to say in Kenya, we are excellent with IT. We are top tier.
Yeah.
Silicon Valley material is here, isn't it?
Yes, definitely.
Yeah, if you
Yeah.
look at smart and the
Yes.
things you do.
Yes.
But a lot of organizations forget about their physical records. They think
That's very true.
that safeguarding is only on IT. So you'll find papers lying around that have personal information, and that can cause great injury to somebody's privacy. So that's one of the principles. The other principle is what we call transparency.
Okay.
So as an organization, you have to be transparent. It's what we were saying when we were talking about consent.
Yeah.
You can't pick people's information behind their back. They don't know. They don't know you're picking their information. How did you get it?
Yes.
There used to be some aggressive marketing tactics some few years back where people would take databases of phone numbers of people.
And then
You
do
have a
bulk
DB,
SMS.
and then you just send bulk SMS.
Whether it applies to them or not doesn't matter.
You buy
Yeah.
first of all, you buy the DB from someone. So do you see that scenario?
Yeah.
Where did you get my information, first of all? Especially if it doesn't apply to me. I will have very many questions. I've never interacted with this organization. Like right now, if Smart decides to do that, many people will come asking, where did Smart
Get my number.
get my number? I've never interacted with this company in my life. So transparency. What are you as Smart doing to ensure that the people know that you are involved and you're a middleman? That is something between you and your insurance providers. There should be some form of collaboration there. So that principle also goes along with something we call fairness.
Okay.
If you're transparent, then you're fair. You're being fair to me. Like if you're opaque and you don't tell me about things and you're hiding, there is an element of unfairness, isn't it? Yeah. So the two things go hand in hand. And then there is what we call also lawfulness, the principle of lawfulness. Basically, I have to have a lawful reason for picking somebody's information and for using it. Yeah. And the reasons are actually in the law. So we are saying, do you as an organization understand your lawful reasons for picking people's information? Why do you pick people's information at the gate? What's your lawful reason?
To identify who is in the building. So in case of a fire, I can do a check on whom have I not taken care of.
What you have given me is a reason. But is it lawful? So you have to have a reason, but you also have to have a lawful reason.
So what are these lawful reasons?
So the lawful reasons are things like consent. Either they gave you your consent, or things like contract, or maybe you want to get into a contract with them, or something we call legitimate interests. That's mostly where this one of picking information at the gate falls. That I need to secure my business premises and the people that are there. That is why I pick that information, isn't it?
Yes, definitely.
Yeah. So that is the second principle. There's another principle around purpose, limitation, which is the same almost as transparency. Do you have a reason for picking my information? Now the other one we're talking about a lawful reason.
Yes.
But then there's also just generally, do you have a reason?
Yeah.
Why? Why should I give you? Yeah, and I like what you were saying. Or if I'm doing a fire drill, if there is a fire and I need to account for the people that were in the building, those are perfectly lawful reasons. But, for example, do you need to pick all the information from a job applicant? Do you need to do a medical assessment on all your job applicants?
Well, that's an interesting example you've brought up, because some organizations actually, before they employ you, have to do a medical check.
Yeah.
So
why?
Maybe to make sure that you're fit for the job that you're supposed to be employed for.
Yeah. So what you're saying is what an organization has to do. Ask yourself why for all the information you hold. And if you cannot explain it to yourself, you most probably don't have a reason. Convince yourself before you can convince the world, isn't it? Yeah.
Okay.
Then the next area is around the principle of data minimization.
Okay.
Again, you cannot pick everything from a person. You need to pick what is relevant for the job that is at hand.
So you're telling me an organization cannot ask me for details of my grandmother?
Why would they be asking you? It goes back again to purpose. Can they justify? Yeah. You know, again, justification is the thing. Maybe your grandmother is your only surviving next of kin and you've put them down there.
Okay.
Yeah.
Okay, yes,
So I'm saying you can never say yes or no. Reason has to be justified. Secondly, has to be lawful. So if you tick those two boxes, then why not? Yeah. But then the information has to be relevant.
Yeah.
Don't go out picking. So do you need all your job applicants to give you a driving license?
No.
Is
If that job does not require
me
you
to drive, why do you need my driving
It doesn't make
license?
sense. Yes,
It doesn't make sense,
Yeah.
isn't it? Yeah. So you're asking yourself, is this information relevant? That's the principle of minimization. We then have another principle known as storage limitation. This one is challenging organizations not to store data forever. Yeah, to have time limits, that when the use of the data comes to an end, you say goodbye.
But who determines that period? Isn't it the organization?
It is.
So I can decide to make it indefinite, since I'm the one who's determining the period.
It depends. Is it justifiable?
Okay.
Again, we go back to reasons. Yeah. For example, there is something like the single patient view and the single patient record. Like you want to have a continuous record of your patient.
Yeah. Across wherever they
in
go.
a hospital.
Yeah.
So it's very possible the hospital will not delete that kind of information. They could have those kind of indefinite clauses.
Yes.
But they are not recommended. They need to be well justified. Yeah. So if you closed your bank account 20 years ago, should the bank still be having that information? Is that relevant?
What if they need it for audit?
20 years ago. Okay. Let's push it. 40 years ago.
Okay, that's still irrelevant, yeah.
Yeah.
What if someone had a 40 years mortgage?
Yeah. Good.
Yeah.
That is the thing. Those are the questions you ask yourself as you're setting a retention limit. You have to ask yourself several things. How would the business need this information? That is a good way.
Okay.
It could also be, what if I get sued? Yes, they are no longer my customer. What if you sue me? How will I defend myself? So that could be another way you can look at how to determine that retention period. It could also be something along the lines of historical value of the information. Does this information have historical value to the organization?
Yes.
So yes, there is no rules around how to set, but there is a requirement to be cognizant that you need to set these timelines and have a policy around it.
Yeah. Okay. Let's look at cases where because you've said the data protection law requires us to set storage limitation. But then again, in my industry, I have a law that says, you have to keep, any data that has maybe financial transactions appended to it for 7 years. Which one takes precedence?
And actually, if you look at the law, there is no conflict.
Okay.
Because what the Data Protection Act is saying, don't keep information longer than is necessary. So if the law has said keep for 7 years, it's still necessary. Because the law has already told you that I need it for 7 years. Yeah. So in fact, when you're looking at retention limits, it's always advised to know what your industry says, what your sector says, the laws around your sector, because it's different things across different sectors. For example, if you're investing in, if you're a company that's processing shares, maybe you're a share registry.
Yes.
Isn't that type of information, can you really delete a share register, knowing that somebody can come for dividends of a relative that bought shares in the 1960s?
You cannot just delete.
You don't know when a claim could come, from a shareholder or the estate, because this is perpetual succession. It will go on forever and ever, this process going on. Then you don't want to have continuous records. So I think in my opinion, look at the law. What does the law say for your sector? Look at your own internal business needs. Look at things like historical value. There are various parameters, but then actually define in your policy, and not, everything cannot be indefinite.
Definitely not.
Some people still want to hold on to everything is indefinite, like employee data. If the person had no pension, and they took all their medical at the day of leaving, is that somebody you want to keep past 10 years? Maybe I'm giving a rough example. After they leave, do you want their data after 10 years? An employee, somebody looks very different in the job market.
Definitely,
So you look at those factors.
Let's speaking into the principles that you talked about. Does this apply to people who have died?
The data protection.
The dead, because I have information I'm holding about an individual as an organization, but this person has died. Do those principles still apply?
Now, interestingly, in Kenya, the law is silent. It doesn't say whether it doesn't apply to persons who are deceased. But when you look at GDPR, it's explicit that deceased persons are not under the Data Protection Act. So, to be on the safe side, take all information that is personal as being applied. Then, of course, there will be arguments. Of course, there will be court arguments about it. And until we get a firm position, I would love to say no and go into the legalese of it. But I look at it towards, if the act is not expressly saying no to this thing, then it means it has left room for argument. For me, for purposes of my organization and to get things moving, I just take all the data as requiring to be protected. Okay, so let's now look at an organization who, let's say, has a revenue of about maybe 30,000 a month. Does that still apply? Or are there certain categories that the regulator has put in place that, if you're this number of employees, if you're this much revenue, then this is what applies to you, or it's blanket? Thank you. So, and there's always that confusion. There's another another obligation that we haven't spoken about. I think we have only talked about the principles so far. The obligation to register as a data controller or as a processor. That one, if you are handling information and you have categorized yourself either as a controller or a processor, and you have met the thresholds.
So what are the thresholds?
For registration, you need to register. So what are the thresholds? So the thresholds are a factor of two things. The nature of your organization, I can even say three. The nature of your organization, your revenue, and your number of employees. So not-for-profit organizations and government institutions, those need to register regardless of their revenue
and employees,
and employees. That's not how we gauge them. The nature of the organization, they'll pay a flat registration fee. Then we have certain sectors that must be registered. We have certain sectors that must be registered, whether they make 0 shillings or they make 100 million. For example, the education sector, healthcare providers.
So you're telling me someone who owns a kindergarten has to register?
Has to register.
Oh, wow.
Gambling. If you're in the gambling sector, you need to be registered. I think real estate is another one I can think of off the top of my head. So those industries, even if you're a startup, as part of your startup requirements,
is to register.
Put registration as one of the things you need to do. Then for the rest of the organizations, you should be registered if you meet to the threshold of you make more than 5 million shillings. You make more than 5 million shillings.
And that's annual, not
annual. And you have more than 10 employees. So if you're not supposed to register mandatorily, so forget the kindergarten that is a startup. That one must register whether or not they have made the 5 million or whether they have 10 employees or not. But for an organization, even SMART has to be registered because you're providing the healthcare services. But there are some organizations that perhaps could not be falling under those mandatory ones. But now what we are looking at is their revenue. So if they're making 5 million and above and they have more than 10 employees, then those people need to be registered. Now, registration is different from compliance. Registration is just an aspect of compliance, one aspect. But it doesn't mean because I've not met the threshold, then I should not comply.
Okay.
Let's say
get you, yeah.
I'm not making more than 5 million and I have less than 10 employees, but I'm still picking data from people. I must still comply. Whether or not I'm registered.
I'm registered. Okay.
Yeah.
Okay.
So registration is not what says that you should be complying with the act. What says you should comply is the fact that you collect data from individuals.
Okay, at least that kind of clarifies it. Because there has always been the confusion of I've registered, so I've complied.
No. It is not evidence of compliance. It is just part of the journey of compliance. A small part of the journey is you need to be registered. A part which has a fine. If you don't register, 3 million is the fine. Or you face an imprisonment term of 10 years. Or, no, I think 2 years. Could be, yeah. So you need to be registered because if you don't, there's a penalty attached to it. But it doesn't mean that if you're not registered, you shouldn't comply. It doesn't mean you can go out and post people's pictures without consent.
Without consent.
Yeah.
And do the scary videos that
and do those scary videos. It doesn't mean because you're just one video man and maybe you make just 10,000 a month through those videos on YouTube. You shouldn't register. You must. You must be registered.
Okay, makes sense. So the first step an organization needs to do is identify what category they fit in.
Yeah.
And then where they're supposed to register or not.
Yes.
So now I've registered, I've identified I am a data controller, or I'm both. I've gone about registration. What do I do next as an organization?
So, and those, I think we still go back to your compliance journey. Have you followed the principles of data protection? Do you have these policies that can show evidence of having complied? And we'll talk about that in the next episode. Then have you put in place a framework for people to contact you if they have questions about their data? That's what we call subject rights management. That's also part of your compliance journey.
But then, Anne, ordinarily, as an organization, I've already put on my website the number you can call. I've put the email info@company.com. I mean, what more should I do on how to...
And it's fine to put those things there, but if I call that organization and I'm asking for a data request, do your people know what I'm asking for? Have they been trained? Which is another aspect of all this, of your compliance journey. Because if I call there and nobody helps me, then you're frustrated my ability to exercise my right. So you must, even if you putting the number and the email is not enough, there has to be some intentionality behind it. Behind the scenes, if somebody actually calls, are they going to actually be assisted? Or is it a cosmetic thing you've put there? You know, sorry, you can't get that kind of information. I don't know what you're asking about. I think you should call another number. Or you take me round in circles for 5 days, I still don't get help. And that becomes an issue.
Okay, so that means my sales@company.com does not apply in this case.
It's advised if the people within sales can be trained and they can identify the information, well and good. They can identify the nature of the request and they can respond to it, well and good. If you're not confident, then you should always have a privacy email or somewhere they can be contacted different from the sales process. The danger with putting in the sales email, it can get lost.
Yes, with the many requests.
With I'm looking for money. I don't have time to respond to requests.
That's very true. Yes.
Yeah.
Oh, okay. So once I've made sure that an individual is able to contact me to exercise their rights.
Yes.
What is next after that?
Yeah. Next, you're asking yourself, if information gets lost in my organization today, am I able to know? Do I have a way for the employees to report to me this has happened?
Yes.
And then am I able to report to the data commissioner within 72 hours? As a controller, you need to report to the commissioner within 72 hours of that occurrence.
So I should have a contact
of becoming
with the
aware, not of the occurrence, but of becoming aware of the event. So, do you have processes in place? That's what you should be then asking yourself. Are you prepared for a data breach?
Yeah.
Have you trained your staff? That's what you would be looking at from that perspective. You'd also be asking yourself questions about your third parties. All these Googles, Smarts, all these people.
Yeah.
Have they complied themselves with the data protection law? Are they a risk to me?
I thought a third party, it's on them to comply. Why should that bother me as an organization. I've already done my bit. I've registered with the authority.
Yeah.
I have done my bit.
Yeah.
Why should I be bothered with the third party? It's their responsibility.
Because remember, we said controller is the person who determines the purpose and means of information, but then they go and subcontract.
Yes.
So processor is a subcontractor of controller. Whatever processor does affects controller.
And the controller takes responsibility.
In fact, when you're reporting, the reports, even if the report happens at the processor, they are not the ones to report. It is you as the controller to say my subcontractor was breached, and they need to report.
Yeah.
And then they need to have adequate safeguards. Yeah, they need to put in place adequate safeguards to safeguard your personal information, and you need to assess them. Do a risk assessment. How much can they expose me?
Yes.
Then give them a good contract.
Okay, so that means we need to tighten the controls with the people who share personal data with as organizations.
Yeah.
Let's look at the concept of having an individual responsible or an office responsible for privacy matters, because we've seen it a lot being prescribed, even in some jurisdictions. I think if the law, even, for example, in Rwanda, they even stipulate you should appoint a data protection officer.
Yeah.
It's stipulated in the law.
Yeah.
In this case, with the law in Kenya, and even GDPR, I think, because most of these laws are picking from GDPR, is it a must to appoint someone who is responsible for data protection? Or you can decide, you know what, we shall all be responsible. Yeah. Is it a must to do so?
So as you can hear, I'm talking about so many obligations. I'm talking about you need to know the principles and follow them. You need to come and prepare for a breach. You need to register. So think of the data protection officer as the conductor of the choir. There are different people doing different things with data in an organization.
Yes.
The people at the front desk, the people in marketing, the people in sales, in claims, in finance, in HR, do different things for different purposes. But all of you need to coordinate your efforts. You all need to speak from the same hymn sheet. Yeah? So who helps to bring the coordination? It is the data protection officer. It is a disservice to yourself, even, in fact, if you don't have this person. Because it means everyone is doing their own
thing, and they're deciding they make their own decisions.
The risk is so high, isn't it?
Yeah.
So when you have this person, they coordinate the activity of compliance across the company. They know what is happening where at any time. And if there is a breach, they can be able to address the commissioner with confidence.
Yes.
You know, on acting with the executive and the management. They can talk together with confidence because they have an understanding of what everybody is doing and what are the plans for compliance.
Okay. As we wind down, I have one last question. So, as an organization, I have done everything within my powers, you know, to comply. That's one. To put in place safeguards. That's two. But there are some things I'm not able to control. For example, I can't control the behavior of my employee. So I give a case. I'm a hospital. Yeah. And one of the nurses decides to leak, you know, information, medical history or medical information of a VIP. I've done everything I can, but I've been let down by an employee. So how does the law treat such circumstances?
Again, everything you can also goes down to policy.
Okay.
So have you made your employees aware that they cannot share information? You can train them.
Yes.
As a basic thing. Then you can make them sign off sheets to show they have actually been trained.
Yes.
Then you can give them a confidentiality agreement. And then now you can come and disown them. Eventually, because you have put in place all these protocols. You have told them. You have actually put a policy document around it. You have trained them. There is not much more now you can do other than now go through a disciplinary process. Say that, in fact, I have trained these people. They have done this maliciously. And you can prove. Look, this person attended training. Look, they have signed this agreement. And look, they have decided to go against it. So you can't also escape and blame your employee if you yourself have done nothing to train them.
To train them.
Yes.
So in that case, if someone complains, the VIP now complains to the authority and says, you know what, my data has been leaked by, let's say, hospital A. How would this be treated in this case? Because I've done everything. I've done the trainings. I've made them sign a confidentiality clause and all this. So in such a situation, how is it handled?
Now, when you hear the word complaint, you see there's a third party now to determine. Now you are saying you've done, they are saying you have not. So the data commissioner, what they do is what she does is she will call for information.
Okay.
Yeah, she will call for information from you as the hospital.
Yes.
Provide, this is the complaint we have, provide your response. So you have to go with all your evidence of what was said, why, when, who was involved, and all those scenarios. Yeah, so it will now be a matter for determination by this regulator, and not you versus the person complaining.
Who's complaining.
Yeah, so that's when you'll be tested on your policies. Because the data commissioner will ask, show me how you have trained your staff. Show me what policies you have in place. The less you have, the worse position you're in.
So more is good.
More is good.
All right. So that brings us to the end of this episode. We largely looked at what is privacy for the organization, what are the obligations an organization has in terms of privacy and data protection. And in the next episode, then we'll now go deep dive into, how do you start on a compliance journey? What is it that you need to do? More of that will come in the next episode. Thank you very much. See you in the next episode. Bye.
Global iTech Podcast. Global iTech Podcast.